of any other law to the effect that a person or authority shall not be subject to the direction or control of any other person or authority in the performance of any functions under this Constitution or that law shall preclude a court from exercising jurisdiction in relation to any question whether that person or authority has performed those functions in accordance with this Constitution or the law. You could be, you are independent, fine, but that does not preclude a court from inquiring into whether or not you've done your work well. And between me and you, my brother, you look at 47.4 and ask yourself, how does the EC determine the means of communication, geographical features, density of population, and the rest? And if you are asked legitimately to explain to the Ghanaian voter how you do these things, should you think that somebody is unnecessarily...
So are these the reasons why you're hitting court again? I mean, seeing that you withdrew the first suit against the Electoral Commission.
I did not. What happened was that whilst that case was pending, the EC went ahead and laid before Parliament CI 73, purporting to create 45 new constituencies to raise the figure to 275. You see, when cases are pending in court, you are not, permitted to interfere with the due administration of justice. Whatever you do, which would amount to making the court impossible, in other words, prejudicing the outcome of that court, is contempt of court. If we are asking you not to create constituencies, hold on, publish the CI, tell us how you go about it, and you refuse, and rather go ahead and lay before Parliament a CI creating the very constituencies we're asking you not to create. First of all, it means that you don't respect the rule of law. Now, if you look at our Constitution, you'll find that we've all committed ourselves, in the preamble of the Constitution, to what we call the rule of law. And therefore, it's a very sad commentary that you have, an institution which doesn't want to do that. If I may skip a few, it says, in solemn declaration affirmation of our commitment to freedom, justice, probity, and accountability, the principle that all powers of government spring from the sovereign will of the people, the principle of universal adult suffrage, the rule of law, So when somebody goes to court and is asking you to hold, to do a particular thing in a certain way, you could go to court and say, no, I don't think that what he's saying is right, and therefore I won't do it. But you don't just, ignore the pendency of the suit and to proceed. For example, there was a specific request that we made, a relief we asked, whether every district ought to be a constituency. The EC has consistently said so. We have said that. If you look at Article 47.2, what it provides is that no constituency shall fall within more than one region. When I read it, did you hear districts? No constituency shall fall within more than one region.
So in effect, I mean, you just cited 45, 47 to support the reason why you're going to court.
No, now I'll come
summary,
specifically
the
to
reason
why
you're in court. I asked why you withdrew and the earlier case, and you said you didn't withdraw. So what happened to that earlier case?
Contempt. You see, whilst the case, the contempt also was pending, he went and withdrew the CI 73 from court. From Parliament. The understanding then was that, well, then there was no more contempt. So I said, well, let me withdraw it. Then he goes back to lay another one. The basis of the contempt was the first one he laid in July. And now a new one had been laid in August.
But withdrawing the first one was technical. It was a requirement from Parliament to correct errors. So that, well, he didn't just go ahead to withdraw it from Parliament. He was compelled to withdraw.
Yeah, so long as it was withdrawn, my understanding was that, well, there was no longer any contempt being committed. He's shown that now he respects the rule of law. The next day, he goes back to lay it. And that creates the difficulty for us. And we said, okay, we would advise ourselves. Now, to the specific issue why we are in court now, you see, I read 45B to you. The Electoral Commission shall have the following functions. B, to demarcate the electoral boundaries for both national and local government elections. I don't know whether you've had opportunity to look at CI 73.
No.
It has 3 columns. One column, I don't have it here though, but one column deals with the constituencies. The other column deals with what we call the headquarters of the constituency. And the third column deals with electoral areas. These electoral areas were created by LI 1983 of the year 2010. Now, the minister responsible for local governments purported to have done that, and he said he was deriving his authority from subsections 3 and 4 of Section 3 of the Local Government Act of 1993, Act 462. The said subsections provide as follows. 3. The minister may, by legislative instrument and with the prior approval in writing of the cabinet, establish within the area of authority of the district assembly the following. 1. Look at the language and listen to it well. Sub-metro district councils. 2. Urban or zonal councils. 3. Town and area councils. And 4. Unit committees. 4. A legislative instrument under subsection 3 shall specify A, the jurisdiction, membership, functions, and responsibility of a sub-metropolitan district council, urban or zonal council, town or area council, unit committee, and B, any other matters connected with the sub-metropolitan district council, urban or zonal council, town or area council, unit committee, as may be considered necessary. You will find that nowhere were the words electoral areas added to the function. But the title says that in exercise of the powers conferred on him by subsection 3 and 4 of section 3 of the Local Government Act 1993, he was proceeding to create electoral areas. So he created the electoral areas clearly in contravention of Article 45B, which says that the Electoral Commission shall have the following functions. B, to demarcate electoral boundaries. It is these electoral boundaries that are found on the third column, which form the basis of the constituencies. Now, it is our case that because they were created by the wrong person, those electoral areas themselves are unlawful, illegal, unconstitutional.
Those are those the only reliefs you are seeking? Well,
clearly, once they go, then it will mean that we cannot hold our elections based upon that CI 73.
So what if the CI passes?
It doesn't. Why should it pass? If it passes, fine. It can pass. But as far as we are concerned, the Constitution is the fundamental law of the land. Under Article 2:1, a person who alleges A, that any enactment or anything containing or done under the authority of that or any other enactment, or B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. So once it is an act of any person which we believe is inconsistent with or is in contravention of the Constitution, we can always go to court and ask the court, that is the Supreme Court, to deal with it. The Supreme Court can declare it null and void.
Well, this is PM Express, and I'm in the studio with former Attorney General Ayikoi Otoo, and we're discussing the legalities of the Electoral Commission going ahead to lay constitutional instrument before Parliament seeking to create 45 new constituencies. Mr. Ayikoi Otoo is in court, is heading to court to sue the Electoral Commission for this, and you've heard a lot of legal arguments. We'll take a break, and when we return, welcome back to PM Express, and my guest tonight is Ayikoi Otoo, former Attorney General of the Republic of Ghana. under the former administration of the MPP government under former President Kufuor. Now, Ms. Ayikoi Otoo, is it fair to say that you're being political in this?
Well, we are all political animals. It's not so much anybody wants him to be political, because in fact, I've always said that even judges cannot claim to be absolutely apolitical. We have had situations where many Supreme Court and other judges have become speakers of parliament. I mean, how do you expect them to go and preside over a highly political house if they had no ideas of doing politics? So we are all in political animals. I'm not being political.
The motive is not political here.
No, we're looking more at the law and holding the EC accountable. I mean, good governance and getting strong institutions. Obama was in this country, made it clear to everybody that what we need is not strong men, but rather strong institutions. So whatever we can do to build the institution, I think we ought to look at it. If you remember Thurgood Marshall of America, he did quite a number of cases in the Supreme Court, civil rights cases. Eventually, he himself was appointed a Supreme Court judge. And he was so respected that I think a court also was named after him. There were a black man, Thurgood Marshall, retired at over 80 years, having worked with the Supreme Court. So some of these consistency and persistence in doing some of these things should not be put down necessarily to one being political. That is number one. The other issue is that in most of the issues that we've taken to court, there hasn't been a clear ruling on any of them. When we went first to the Supreme Court, we were advised to take the matter back to the constituency dispute settlement, boundary dispute settlement tribunal. And so the matter was not gone into. When we went there, they told us that the CIA had not been laid and had not passed, so we cannot claim to have been aggrieved. Because see, the words of Article 48 to me are very clear. A person aggrieved by a decision of the Electoral Commission in respect of a demarcation of a boundary may appeal to a tribunal consisting of 3 persons appointed by the Chief Justice and the Electoral Commission shall give effect to the decision of the tribunal. So it appears that you must be aggrieved by a decision only after the boundary had been demarcated. And we thought that, the advice of the Supreme Court to go to this boundary settlement dispute tribunal was rather without any basis. But that was the ruling of the Supreme Court, so we were compelled to go there. We went there, predictably. They told us, no, they do not have jurisdiction now. They think that our case was a little bit premature. So we went back to the fast-track High Court to ask the High Court to, deal with the issues that we have raised, which were not necessarily connected with demarcation of constituencies. The High Court also ruled the same way, that because the Supreme Court had said that we should go to that court, then they think that it is that court that, in law, res judicata arises where a matter has been heard to its merits, on the merits. It be heard to its logical conclusion and be held on its merits. But where you've not heard the case, then you cannot say that the person is stopped or that there is some amount of res judicata. Nothing happens. You can always go back until the matter has been heard on the merits. So we are not being political. We are not being fussy. We're trying to get the EC get up to its responsibilities
and abide by the laws of this country.
So.
Now, let's quickly talk about the creation of these 45 new constituencies. Recently, the NDC held primaries in some of the selected constituencies to elect members of parliament. The NPP said that that was absolute illegality. The NDC thought, no, it was within its purview to prepare, make itself ready ahead of the CI passing. Now, are these all part of the considerations for which you're going to court?
Well, it's not directly connected with that. But one would have thought that if we are all into the rule of law, then we would allow the law to pass. Then we know that we have constituencies that we are contesting for. How come that we have about 5 registered political parties or so, 6 or thereabouts, and it's only the NDC that appear to be preparing very feverishly towards, the creation of new constituencies? All the other political parties have just stayed put.
But they explain that they don't want to be caught unawares. They want to be ready when the CI passes. Is there any illegality in this?
Well, the illegality is obvious to everybody. You don't even need to be a lawyer to understand that you do not contest for constituencies which do not exist in law. Do they exist? It is only when that CI passes that will add 45 new constituencies. For now, we have 230. And you say you are preparing an older elections. And to add insult to injury, you have the same going supervising those elections. I mean, I do not see what the worst kind of illegality and a slap in the face of the rule of law than what the EC is doing. At best, it could have just stayed out. In any case, if you look at its functions under Article 45, is to conduct and supervise all public elections and referenda. These are private elections. When the NDC decides to hold an election within intra-party, something private.
But the Electoral Commission has supervised MPP primaries also.
Yes, so they are only invited to go. So it is for them to say that, look, we are sorry. Now the law has not passed, so please do your own thing. When the law passes and we are invited, then we would come. But for now, to go there, to give, a blessing to it, what is it that you are doing?
But the EC has said that going ahead to supervise these elections are not an illegality, and that it's not its business to determine who represents a political party in a constituency for parliament.
Well, you see, I remember after the primaries, there were those who were not happy with the outcome. And some decided to sue the EC and the rest. I mean, they had to come in quickly to say that it was not part of their normal business and that they were merely invited to come and assist. So they would have thought that they would have been left out completely of this kind of mess if people have a difficulty with the way their officers, supervise the elections. That tells you that they are aware that what they were doing is not a function under the Constitution or any other law. But they were merely invited, and they go to supervise just to assist, to put some a semblance of, if you like, constitutionality around it. But they are not obliged to do that. And in this case, where the law has not passed, I mean, can you fancy people holding elections for constituencies that do not exist? How on earth could the EC be seen to be part and parcel of this kind of illegality? What is happening there? You see, what would happen? Assuming that the Supreme Court goes ahead and strikes out this CI, what would have happened to those people?
They will wait. I mean, they're still private citizens. They haven't contested an election for an EC-organized election yet.
Yeah, it is easy to say so when you have not gotten through primaries before. But if you know the amount of monies that people spent in getting themselves ready for this kind of election, you will find that it's not.
So what you're saying is that the EC, despite the Commissioner Afarijan saying that it is unaware of any constitutional provisions or electoral law that bars it from supervising any primaries, you still feel that there's no basis for going ahead to?
No, there's no basis. He himself agrees that they are merely invited to go and assist. There's no basis for it. I read to you to conduct and supervise all public elections and referenda. It's not part of it. I mean, private elections are not public elections.
So are you taking an action on this one too?
Oh, no. Why? I mean, there are things that sometimes you let the electorate take a decision on the matter one way or the other. If they think, and it's very painful it's a regrettable thing that is happening, especially to Dr. Afarijan. You see, he's held elections in this country, supervised elections. He's done so well. He's been commended. He's even been invited to supervise elections in other countries. And on the eve of his retirement, when things appear to be going this way, as if he's being pushed by the government in power to do its bidding. It's rather a regrettable phenomenon to observe. That, I agree when we talk about independence, it does not mean financial independence because it may not have its own resources. And therefore, you may rely on government to assist you with funds. And there are times that the EC complains. For example, the problems we had with the district assembly elections, they had to be postponed several times. And I believe one of the reasons was that money was not released early enough for him to undertake the exercise. So when it comes to financial independence, fine, if you are dependent upon government. But beyond finance, the rest, you should be able to assert your independence and just look at the law to guide you in all things you do.
Well, we have some of your comments coming in from our Facebook. John Kwejo Opoku entry, you write that, yes, he could have hidden behind someone to avoid the political tag. I'm not sure whether, John, you're referring to Ayikoi Otoo or you're referring to the Electoral Commission or its commissioner, Dr. Afarijan. Abdullah Ambitious Rahman, you write that he's being apolitical for the right thing to be done. How can the Electoral Commission be supervising elections that have no legal backing? If there is any chaos in the country come December, then the EC is responsible for that. Dixon Desire from Laura writes that Mr. Otoo is the kind of person we want to hear in Ghana. Will the EC not be able to conduct the general elections without the creation of these new constituencies? The NDC is just doing all they can to stay in power, but they will not succeed. The timing and creation of these constituencies is just wrong. EC, we need peace after the elections. God save us. And then Nyansapo Love writes that, Honorable Lawyer, who is pushing you to do this? We'll bring this question to Honorable Ayikoi to answer. Ayim Roja writes that, ask him why he knew it was unconstitutional, but his party in government used the same processes to create new constituencies just before the 2008 elections. Charles K. Zohache, I think that's correct. I wish the host will introduce him properly. That's former MPP government attorney general, an MPP member, so that we know where he's coming from. And then Seth B. Wright says, the question is, has he the right to sue? What may be the outcome and not whether he's MPP or not? Let's respect the rule of law and always uphold the great constitution. Charles again says that my question is, what other method does he think should be used to review constituencies? Why is he trying to stop my area from getting a constituency? Kwame Asari also says that I think those who are pushing the Electoral Commission to create this untimely and illegal constituencies must be arrested and prosecuted for causing fear and panic. I don't know about that. Ayikoi Otoo has done nothing wrong. And Isaac Kwejo Obing says, Honorable Ayikoi Otoo, it's a true Democrat who understands the rule of law. We need such people to fight to deepen Ghanaian democracy. The intention of the Electoral Commission to create the new 45 constituencies is too appalling and will be in vain. Honorable Ayikoi Otoo, you had those comments, but let me ask you, what are the implications of all of these to Ghana's democracy?
Well, I think that timing is a problem. To create a new constituency means that the parties must have to also have what we call polling station executives. And then they have to go through primaries to elect a candidate. That candidate must have to campaign for the elections, so it could be elected in December. You know, if you look at the time, it seems to most people that it is most unreasonable. We are in August, we have September, October, November. As for December, you don't count it because it's the very first week. So it means we have only 3 months left. How do you expect people to organize themselves to contest elections? Elections are not like district assembly elections. You need to print posters. You need billboards. You need to mount, rallies, and all the things that go into campaigning, door-to-door campaign. You need even to know your constituency. At this stage, where constituencies are being divided, it means that the boundaries may have to change. So those who have been campaigning in certain areas all of a sudden will now wake up to find that, look, I no longer belong to this area, I should rather be pushing to that area.
There are those who argue that the MPP, whilst in government, created and reviewed constituencies upwards before the 2008 election. So why are you stopping the NDC from doing the same, really?
No, you see, nobody is stopping the NDC. Nobody is putting it at the doorstep of the party. We are looking at the Electoral Commission. I read to you Article 47.1, which provides that Ghana shall be divided into as many constituencies for the purpose of election of member of parliament as the EC may prescribe. So it is the function of the EC to, create these constituencies. If the EC thinks it ought not to be done, it should not be done. Again, in 2000, the argument, I am aware that the law was made earlier. By January or so, we had a new law. So there was plenty of time for everybody to prepare before the elections in December. What is happening now, as I said, is a most unreasonable period. And no, we do not understand why the EC should be pushing it. If at the time he went to withdraw the first CI from Parliament, our understanding was that he had maybe advised himself that it was unnecessary at that stage to even lay a new one. But as we saw on television and the way the majority leader explained the position and assured the House that he was going to withdraw it the following day, and then maybe a new one will be relayed and all that, as if it was the baby of rather the NDC and not that of the.
So you also still hold the view that these creation of constituencies favor the NDC government?
You see, that brings to sharp focus Article 47.6, where the boundaries of a constituency established under this article are altered as a result of a review. The alteration shall come into effect upon the next dissolution of Parliament. Now, it is true that this article or clause has received some judicial interpretation, but the argument being made is that if you want to avoid gerrymandering, In other words, where you create constituencies to favor the government in power, then it should not take place immediately the constituencies are created.
So under the circumstance, for example, if this goes through and then the constituencies are created, they cannot come into effect until this parliament retires.
Well, this one has received judicial interpretation in the case of Luke Mensah versus the Attorney General. And now appear to be saying that because in Ghana, elections are held before the dissolution of parliament, therefore, the interpretation is that we should have two stages. The first stage is creation of the constituencies, and then the second stage will be the election in December. And then after the dissolution of parliament on the 6th of January, then on the 7th, the new people will now take office, which would amount to, which would then come to what they call the next dissolution of parliament. But the idea is this, that perhaps a proper or a better interpretation should have been that since it is the government in power which appear to be pushing the electoral commission to create it, it should not take place during the lifetime of this particular government. We should allow the elections to be held as it stands, and then it should take place in the year 2016. Now, gerrymandering, I'll tell you why that argument is being made. We have been told that YEC looks at population and land. In terms of the census, Accra has the largest population. In terms of numbers, that is voter population, in terms of population itself and landmark population, you have Kumasi, our Asante region. Volta region does not come anywhere near Accra in terms of population. Now, Volta region and Greater Accra are going to get almost the same number of seats. The MPP has 1 seat in the Volta region. If you add 8 more seats to Volta region, what have you done in effect? It means that you have given them 8 new parliamentary seats, isn't it? So that is the meaning of gerrymandering. So you see that, look, we are strongest in Volta, so why don't we add more seats there? Then you come to, say, parts of Greater Accra, where we have, say, Ada. Ada has traditionally been won by the NDC. And then you create Ada East from it. What have you done? You've given them 2 seats. Ningo Pram Pram. Something that has been won by NDC. And then you create it or split it
right,
into
we'll take
2.
a break.
What are you doing?
We'll take a break now. I'm sorry, Honorable Ayikoi Otoo. And then we'll return to delve deeper into that angle.
Welcome back
of
to
gerrymandering.
PM Express. If you're watching us, you may be wondering why we don't have a representative from the Electoral Commission to answer some of the issues that were raised. Well, we've been trying to bring them into the discussion, and even as the discussion is ongoing, we're still trying to call so that at least we can get their side of the story. So if the EC is listening to us, we're trying to call you so you can contribute to this discussion, these very important discussions. Now, is your lunchtime always a hassle? And worry no more, because with MTN mobile money, getting food from Papaya, KFC, Frankie's, Honeysuckle, Walker's Pizza, Eddie's Pizza, Barcelos, walk-in Chinese restaurant, etc., has now been made much easier and convenient. You can visit store.moneyclick.com, http://store.moneyclick.com, or call 0244-783-838 and www.runnersdeliveryghana.com, or you can call 054-8710768 to place your order and pay conveniently with MTN mobile money. Live the easy life with MTN mobile money. For the month of August, you can get the following discounts when you order food and pay through MTN money. From MoneyClick, you get 20% discount on delivery charges. From Runners Delivery, you get 50% discount on delivery charges. You can also celebrate this August with MTN mobile money. Send 50 Ghana cedis or more to your relatives and friends through your MTN mobile money wallet and enjoy 10 Ghana cedis free airtime each for yourself and for your recipient weekly. Also enjoy 10 Ghana cedis. You also enjoy 10 Ghana cedis free airtime anytime you shop up to 50 Ghana cedis and above and pay through MTN mobile money at the following merchants: Maxmart at 37, Melcom Industrial Area, and online at ghanabuys.com and ghanamart.com. MTN mobile money is safe, secure, and convenient. So go on, show some love to your friends and family and enjoy this amazing offer from MTN. Promo ends on 31st of August 2012. Terms and conditions apply. MTN Money, experience it. Now, welcome back from the break, Honorable Ayikoi Otoo. You were giving us explanations, in-depth explanations about what you think that this whole thing is, how this whole thing is contributing to the perception of gerrymandering. You mentioned specifically Volta region and Ada and Ningo Pram Pram. Can you explain this further? Because by the mere creation of these constituencies does not automatically mean the NDC has won them or will win them.
Well, we know what we call swing regions. Greater Accra and Central Region traditionally are swing regions. In other words, in a particular election, for example, in 2000, along the coast, MPP won almost all the seats. And 2004, we lost some. And by 2008, with the exception of Tema East and Tema West, NPP lost almost all the seats. Now, projections show that about 7 of these swing regions, according to Ben Efsing, 7 seats in the Greater Accra along the coast are likely to swing back to the MPP. So when you see areas which are swing, then what you say is that it is never a safe seat for anybody. You cannot say the same thing for Asante region. You don't expect the NDC to do extremely well in a particular election. Maybe in 2000, NDC winning about half the seats in Asante, and then 2008 losing. So they cannot. At best, they can win the traditional areas that they have already been winning. So that with what all that you do is to win your primaries and you are safe. People like Doa Jawu, people have been fighting Aveno, he's been there throughout his life. Once you are in the Volta region, you win primaries, and that's it. You come to parliament. So there's nothing swing about those regions. They are safe seats. And therefore, when you start creating more seats, clearly against the EC's own formula, against its own formula of land as against population, because you don't have the population, but you are just pushing constituencies there. Sometimes to the extent that you say every district should have a constituency. And you know that it is the sole prerogative of the president to create districts. Well, the president knows that after he has created districts, the EC will follow up and create constituencies. So the government will create districts in areas where he thinks is strongest, and tell them that, look, I'm bringing you districts so that you have development.
So really, what alternative method would you have had to review these constituencies? Tell me.
Well, the method, as I said, is clearly stated in 47(7), that for the purpose of this article, population quota means the number obtained by dividing the number of inhabitants of Ghana by the number of constituencies into which Ghana is divided under this article. So we just take our population and divide it over the number of constituencies, and so be it. That is number one. Number two, that he should publish the formula that he has been using, because he is an independent.
Is it the same thing that the NPP did in 2008? Did the Electoral Commission publish the formula in 2008?
Does it matter? I don't think that it matters.
But if they did not,
no,
and
the
they
point
are not
I'm making
again,
that
then there is some consistency in the way of doing it.
The point is this: the fact that it was not done in 2000 or 2004 doesn't mean that we are forever closed from doing that. Then our country will not develop. We need to develop, and therefore, if we find that things were not done properly in the past.
So is it to accept that you accept that during your tenure as Attorney General, for example, and during the MPP period, they did the wrong thing by going ahead to review these constituencies up to 230?
Yes.
They did the wrong thing?
Yes. Let us say that it was done, but not in accordance with the provisions of Article 47, because Article 47 tells us how it ought to be done. The fact that it was not questioned, and that is one other matter. You see, you may go to court, and if you don't find resistance, you may get through whatever you want. But once somebody resists, then you have an issue for determination. So if at the time it was done, nobody questioned it.
So the MPP also perpetuated an illegality, which is being repeated in the NDC.
If nobody questioned it.
So why didn't you go to court during the MPP time?
Why should I? Why should I?
So would you have gone to court if the MPP was in power now?
No. The point is this. Did anybody question it? It was not questioned.
Why didn't you question it?
It is now that it's being questioned. It is now that it's being questioned. Even there, as I said, we gave them a lot of time. It was done sometime in January, and they had more than 10 months. And yet nobody questioned, nobody raised an issue.
So what is good for the goose is good for the gander, right?
Of course, no. Once issues are raised, then the Supreme Court must have to look at it.
Why didn't you question it?
There's no point in questioning it at the time.
And why are you questioning it now?
It doesn't really matter. It can be questioned and issues can be raised at any point in time.
Are your conscience clear?
There's nothing about conscience in this matter. I don't think.
I mean, one of our viewers said that we should introduce you as a former Attorney General under the MPP, and then you are an MPP man, so that we lay the foundation clear for everybody to understand where you're coming from.
I don't think
so. It doesn't look like you can tear yourself away from the fact that you're being political.
No, I do not think that anybody has stopped the NDC from doing anything they want to do. If they want to raise issues, why didn't they raise them? If they go to court and they are losing cases, for example, and we did not lose cases, what of that?
So could
that be a reason?
Do you expect that all this back and forth, court, CI, withdrawal, relay, do you expect that it's going to have an effect, some kind of effect on the successful conduct of this year's parliamentary elections?
Clearly, it is worrying. It leads to a lot of anxiety. I mean, if you find yourself in...
Are you worried yourself?
Yes, I am. If you find yourself in Ablekuma's house, and today you hear it's going to be split, tomorrow you hear it may not come on, what are they doing to you? I'm telling you that at the end of the day, you will not even know your
So why
boundaries.
not let sleeping dogs lie then? Forget about this and then let it go and let us have 45 new constituencies, which it appears the NDC is hopeful that there will be 45 new constituencies.
They could continue to hope, but the law is irresistible. That is what I would tell them. They could continue to hope, but the law also is irresistible. So the court would not allow illegalities to be perpetrated.
So really, I mean, I still insist that whilst Attorney General, you could have gone to court. You could have stopped the perpetration of illegality during the MPP era. So if you didn't do that, then you have no moral justification to go ahead to do that now.
I don't think so. I have said that it is for the persons who have issues to raise, who must raise them. It doesn't matter when they are raised. If that were so, then once an illegality is perpetrated, we have to accept and live by that. But it is wrong. Once a wrong, always a wrong. And therefore, it ought to be corrected. It is better. I can cite several examples. There was a justice of the Supreme Court who went beyond his retiring age. Why didn't we allow him to go on? But somebody decided to challenge that thing in the Supreme Court. And his own colleagues told him that, well, my lord, we think you have no business being here. And he was shown the exit. Would you say that that was commendable? His own brothers with whom he sits told him that we have looked at the Constitution, all the provisions dealing with your retirement, and we think that you have gone beyond your retiring age, so please go home. By that time, he had done about 2 years already in that illegal office.
Are you hoping that the MPP will win this year's general elections and form the next government?
I think that the writing is on the wall.
That the MPP is going to
He's
win.
winning this election.
So if should the MPP win and perhaps goes ahead to win more of these 45 newly created constituencies, will your court case still stand?
I don't think that that argument could be made, because if they are declared unlawful and illegal, then no elections could be held within those constituencies. So those 45 could not be part of the 230.
You are
it is
confident
only
that
when they are not declared unconstitutional that the elections could be held in those constituencies.
but there is a likelihood, there's a probability that they could be declared not unconstitutional.
Yes, then we will contest them.
And how long will you continue contesting? How long will you do this?
No, contest means taking part in the elections, because that will be the law. And in accordance with the rule of law, we'll have to go and contest the
and
elections.
by which time you wouldn't be ready, your party wouldn't be ready. I mean, the NDC would have had all its 45 parliamentary aspirants ready.
We would be ready.
How would you be ready? Magic?
It is no business of yours. Leave it to our party. And we know how we go about it.
Okay, thank you very much, Ayikoi Otoo, former Attorney General under the Kufuor administration. He's suing the Electoral Commission over concerns with the creation of the 45 new constituencies. Thank you very much for your comments by text and by Facebook. Stay with us and join us again for PM Express tomorrow. Good night.